There has been a slight change in the order of proceedings today, and our first speaker this afternoon will be Charles Scott of the Ogilvy Renault firm, who is going to be talking to us about, and I'll just read the topic heading, Proving Authenticity of Electronic Contracts, the Challenges of E-Commerce in the Courts under Bill 88, which I understand is now passed. Mr. Scott, as I think virtually everyone here knows, is one of the most prominent commercial civil litigators in Toronto and probably, in fact, the country. Presently at his firm of Ogilvy Renault, he is a dominant force on the commercial list, and he's been at another place before, which I won't mention, but I had the privilege of working with him in a very junior capacity at that other place. So I would ask you all to welcome Mr. Scott.
It was either jail or Tories, and I'm pleased to announce it wasn't jail. Thank you, James. I'm delighted to be here. I'm substituting for Pat Flaherty. I left in the middle, before the main course of a dinner that my firm was giving for one of our most important clients at the Toronto Club today. You know, it's the kind of thing you don't do lightly, but I understand that Pat had to go to golf school to straighten out some kind of banana ball problem he was having. So I think for the larger good, I think it's worthwhile that I switched with him. I want to issue a bit of a disclaimer before I start. My friend George MacDonald in Halifax says that in the Maritimes, an expert has three characteristics: wears a blue suit, comes from Toronto, and has a pointer. I'm from Toronto. I thought I wore a gray suit, but it turns out to be blue, so I'm in trouble, but I don't have a pointer. So I'm not professing to be an expert in this particular field. I've got some experience in the electronic field. But as you know, in the civil courts, unless you get into a very strange situation, many of the rules of evidence are more honored in the breach than not. But it's a topic that you have to know in case you come up against somebody who's got a particular view of things, and so you try to do the best you can. It seems to me that our governments spend a lot of time and money trying to encourage economic growth and development. Sometimes they use our tax dollars for subsidies. This is often expensive for the taxpayer and is attacked by other governments under NAFTA or whatever is the acronym of the day. They can impose import duties and impose general red tape, and that usually has the cost of making goods and services more expensive in the home country. Sometimes governments can use innovative techniques like educational facilities, or in my view, one of the best ones is providing a really good court system. I have long thought that the government of Ontario and perhaps other governments in Canada can promote economic well-being in this province by this technique and by making it attractive for businesses to come here. Are people going to move to Ontario because we have a great court system? Probably not. But that's one of the factors, in my view, that can have a positive influence. And it has, I think, in some respects, done that. James indicated my sort of affiliation with the commercial list, and that thinking was in part behind the establishment of the commercial list, an effort to give a fair assurance to business people around the world and around the country that they don't have to go to the federal court for the Southern District of Manhattan, or they don't have to go to the Chancery Court in Delaware to get prompt, knowledgeable, and sensible decisions on major corporate commercial transactions. The progress that the commercial list has made to that end has been good. It's an effort that has to be sustained. You can't rest on your laurels. What does all of this rant, you'll say to yourselves, had to do with evidence? The changing landscape in the commercial world and the development of e-commerce and email and e-business and all of that has dramatically transformed the way many people do business. the government of Ontario has taken two important steps to the making that kind of business more efficient in this province. The Electronic Commerce Act of 2000 and amendments to the Evidence Act. These are not, in my view, giant steps. They are, in some respects, very timid steps, but they are a decent start at the problem. Business people will want to have, and we will get, because of the implementation of these proceedings, greater certainty that electronic contracts will be enforceable in this jurisdiction. And individuals have been given certain protections as well as certain assurances that their electronic contracts will have legal force. For public authorities in the province, their participation in this new system of e-commerce is voluntary. One hopes that with some other points in the scene that will soon become mandatory for them to participate. One of the best things that one can say about the new scheme that's been introduced is that it does appear to follow both international and the national models. So there seems to be a consistency within this province of the systems that have been introduced in other jurisdictions, and that can only be good from the perspective of those who engage in international e-commerce. The system does not mandate or require any adherence to any particular codes or methods of doing business. And it also all seems predicated to a large extent on the mutual consent of the parties to the electronic contracts. So you can only go on consent, and there is no bold definition of new standards. Presumably at some point those features will both fall away, but they're both prominent in the current scheme. Nonetheless, even with those caveats, we should see a major increase in the commercial transactions that are completed electronically, and that increase in commercial activity will undoubtedly result in more litigation about those electronic agreements. The Electronic Commerce Act provides very little procedural guidance for the admissibility and authentication of electronic documents in legal proceedings. A contract that is only done electronically does pose a number of difficulties and a number of problems. The fundamental problem, of course, being how do we know that what is said in court to be a physical manifestation of an arrangement of electrons on somebody's server is the same physical manifestation of those electrons on somebody's server that the parties thought they were agreeing to. That's the fundamental crux of using electronic documents and having them accepted in a court system, based as it is, as you know, historically on deeds and seals and signatures and pieces of paper, even now photocopies. The purpose of the Electronic Commerce Act is set out neatly in its long title, which sort of surprisingly for this government isn't itself a rant. It just says that it is an act to promote the use of information technology in commercial and other transactions by resolving legal uncertainties and removing statutory barriers that affect electronic commerce. The real guts of the act is in the first couple of sections after you get to section 4 that provides for what are called the functional equivalency rules. And those rules essentially provide that if you meet the various conditions, an electronic contract will have the same kind of status if you deal with certain elements, and the statute purports to address elements of delivery, issues of whether documents are originals or copies, retention of those documents, and signatures. Now, the first kind of really gripping piece of news that when you read in section 4, it is that a document or information is not invalid or unenforceable by reason only of it being in electronic format. That's not the kind of stuff that you're going to found a revolution on. It's not the same as "Oh, Batty Cad." It's not the same as "Give me liberty, give me death." It's not even the same, not even as good as "Make love, not war." But that's as strong a statement really as we get. Nothing in the Act, as I've said, requires anybody to use, provide, or accept information electronically, but it does say that a legal requirement that information be in writing is satisfied if the document is in electronic form. So when you wrap all of those thoughts together, I think that the syllogism is something like this. A document is not invalid if it's electronic. It's not mandatory that anybody accept an electronic document. You can consent to accept a document electronically. The consent may be inferred from your conduct. And if there's a legal requirement for the document to be in writing and it is accepted voluntarily, that is good enough to make it binding. Now, all of that's a little complicated, but that's the way I think you have to analyze the syllogism that comes out of the statute as it currently is. How do you provide a document or information electronically? If you're going to do it, it has to be accessible for subsequent reference by the person to whom it's provided, and it has to be capable of being retained by that person. It's quite interesting. Section 9 of the Act says that a document is not capable of being retained. This addresses the retention issue. If the person who sent it prevents or does anything to hinder the printing or the storage of the document by the recipient. What's interesting about that is that it doesn't say that the person can't do it. It says the document is not capable of retained if a person does anything to hinder its printing or storage, whether that is successful or not. So you can imagine failed attempts somehow, and I'm sure there will be litigation about this, to prevent the full document from being stored or printed. Even if those are not successful, the person gets the document, gets the information, at least the way the statute reads to my interpretation of it, that's not good enough. A document, the statute says in section 10 that displaying a document on a website, which is not defined, but I guess we know what that is not itself sufficient sending of the document. That can only be done as part of a transaction. Now, I don't quite know why there is a distinction between the passive display of a document on a website, which is somehow part of the communication, or showing that document as part of the transaction, but that's what the Act seems to say. The Act also addresses electronic signatures. Now, we know about what a handwritten signature is. It's not the pen that's important, it's the person behind the pen who's moving the pen and creating a signature. It identifies the person, and it acts as some kind of independent authentication of the document, and it attaches to the document. Now, both those notions are picked up by the statute, and the statute talks about an electronic signature that has quite a specific meaning. Electronic signature in the computer world is really a process of encryption and decryption. I'm not going to take you through all that, but there are things called public keys and private keys. Private keys allow you to encrypt a document in such a way as to identify you and to attach to the document. And that's something that's private to you. That's a signature. A public key allows anybody else, not as powerful as a private key, but it allows anybody else to read the document and to verify that it's your private key that's attached to the document as authentication. So it tends to authenticate both the signature, the person sending, and that that signature has been attached to the document that's being examined. Now, all of that produces some very interesting problems, and we're going to face these issues when the statute then talks about an electronic signature. It has two requirements. An electronic signature under the statute, Section 11, has to be reliable for the purpose of identifying the signer and also for the purpose of associating the signature with the electronic document. So it attempts to encompass both of the functions of a signature on a piece of paper. I was to say, we're going to face these issues as lawyers, particularly with the advent of IJP, integrated justice. Many of you will have been participating in the e-filing system. As the new IJP system is rolled out, you'll have to attach a signature to filings you make with the court. And there are proposals underway for judges to issue orders electronically by the application of their signature. Now, how many of you now actually are the person who physically sends a document by email to the court? Judges all sign. How many of those judges are going to be the only sole custodian of the computer that applies an electronic signature to their court orders? Are we going to have our secretaries or assistants do that? Is the registrar going to do that in the court system? How are we going to deal with that kind of issue for ourselves? And how is that, if, as I suspect is the case, some judges want nothing to do with a computer. Some lawyers want nothing to do with a computer. How do we take those real-world examples that we can see and apply them to the statutory requirements? We're going to have to give over to somebody else, or the business people are going to give over to somebody else, the ability to use their signatures. And once you do that, then how have you, in fact, guaranteed the authenticity of a document? I think it's going to be a very difficult task unless the courts are extremely strict in applying the rules that if a signature is on the document, it's yours, and they'll brook no contest about that, which may be the case. But you can imagine cases of fraud, negligence, stupidity that may allow the courts to push back against that proposition. At any rate, the statute says you have to have an electronic signature, undefined, that provides those two functions. The statute also seeks to address the concept of originals and copies. Now, originals and copies have some semblance of meaning today. We know what an original document looks like, sort of. We know what a copy looks like, sort of. In the electronic world, it's a very difficult proposition. As you start keying in things on the computer, those little physical, mechanical motions turn into electrons in the random access of your computer. And when you save it, that gets saved onto some other piece of mechanical, electromechanical equipment. Where's the original in all of that? Once a document's stored, and once you take it out of your Palm Pilot and you send it to your computer, and the computer saves it and puts it on a server, and you retrieve it back and you analyze it, once you do all that, even after you say to yourself, this document is now solidly in the computer, almost every time you turn on your computer, something will change about that document. I was told yesterday by someone who should know that simply by turning on a computer, you probably are changing the data that's stored attached to over 200 files in your computer system. If you simply highlight a word processing document on the pick list in Microsoft Word, just by highlighting it, not by opening, just by highlighting it, you change the electronic characteristics of that document. All of the word processing programs retain information about who's touched the document, when it was last opened, when it was last changed, all kinds of information. So how do you decide what's an original document and what's a copy? The statute tries to take all of this into account, and it says that the criteria for assessing the integrity is whether the information has remained complete and unaltered apart from the introduction of any changes that arise in the normal course of communications, storage, and display. Now, given that breadth, a recognition of how things work in the real world, I still am not sure what is an original document and when you can rely on it. People's clocks are wrong in their computers. How do you know what's, if someone swears up and down, I talked to him at 5 o'clock, we made the deal, we click, click, click on a computer, and you go and look at it, and the stupid computer's got 7 o'clock on it. There's a whole bunch of issues out there. I think you're going to have to be advising your clients in the commercial world that probably just keeping a copy of the supposed document on a floppy may not be good enough. You may have to put it into some kind of hard copy, like a CD-ROM, that by and large, if you pick the right kind of CD-ROM, it can't be written to again, so you can have some integrity. It's got a date stamp it. You're going to have somebody say, I check the clock every day. The clock was always right. It was never off by more than a few seconds. You may have to go to be able to prove that there's a business records level of integrity for the storage and backup systems when you've got thousands of documents to worry about. I think the individual is going to be at a considerable disadvantage if there's some dispute about what forms the original of the document. And those on the other side of the contracts and of consumer contracts, at any rate, who have backup systems and make copies are going to be at an advantage in all of that. Let me talk for just a little moment about electronic contracts and automatic acceptance, which the statute also addresses. Section 19 of the Act provides that contracts may be concluded partially or entirely through electronic means, and that you can do that by touching or clicking on an appropriate icon or other place on a computer screen. So that's what they call in the business the click-on agreements. You click on, accept, I don't accept. The Act doesn't require any particular identification of who's the contracting party. So you can imagine there's going to be some interesting litigation about who exactly is clicking on when your 10-year-old signs in and buys you a $190,000 BMW Z9 and clicks on, and it's your computer and it's your signature. How are you going to prove? I didn't do that. The 10-year, he did it. How are you going to do that? Not going to be easy. But the courts are going to have to develop some system, and you're going to have taken some steps to protect your signature. How you do that from a 10-year-old who probably knows more about the computer than you do, I'm going to leave for you to solve. Section 20 provides that a contract may be formed by the interaction with an electronic agent and an individual, or by the interaction of more than one electronic agents. Understood literally, machines, or electrons within those machines, can now enter into contracts on behalf of their masters all by themselves. If your computer dials into some service and manages to click on, and some other automatic computer at the other end of that telephone line accepts all of that, you've got a contract and no human ever knows about it. There are specific provisions in Section 21 of the statute for correcting errors, but only some errors. And those errors are errors made by individuals interacting with another person's electronic agent. Among the things that you have to prove to be able to get out of to use the error mechanism, the escape mechanism, you got to prove that you made a material error, that the electronic agent did not give the individual an opportunity to prevent or correct the error, and that there's notification immediately, and that you either haven't had any consideration or you've destroyed the consideration that you got. Qualifiers like material and promptly, I don't know how the court's going to deal with those. And I don't know how you're going to find a system that doesn't give an individual an opportunity to prevent an error. I guess why would you click on the thing if you're trying to prevent it? So I don't know whether that's going to be worthwhile or not. It does seem to me that those on the other sides of contracts who are going to be using electronic agents are going to have to be able to prove for any given day or time that their electronic agent did allow that kind of error correction. Otherwise, individuals will be able to avoid the click-on, the results of their click-on. So there's going to be, I think, now an added impetus to make sure that there are careful backups, careful documentation about what the system was on any given day. there will be a real premium for those who keep business records. And where does the onus lie as to proving whether there was or was not this kind of ability? The error correcting mechanism in the statute does not apply where two individuals are engaging in an electronic communication. It only works if you're talking to an electronic agent. There is no provision for recalling the accept or recalling the email. Email systems do usually allow you to recall messages and to get them back. But as you'll see in a moment, from the point of view of when the contract is made, that really doesn't matter. Because recalling the message, even if it's recalled, even if it's not acted on, doesn't match up with the criteria set by the statute as to the time and place, and particularly the time when these contracts are entered into. Let me talk briefly about that. Section 22.1 says that electronic information is sent when it enters an information system outside the sender's control, or if the sender and the addressee use the same system when it becomes capable of being retrieved and processed by the addressee. So it's sent when it gets out of my computer into some other system, and it becomes capable of being retrieved and processed by the addressee. It's deemed to be, it's presumed to be received when it enters that information system and it becomes capable of being retrieved where the addressee uses his or her own system. And in the case of using a third-party system like Hotmail or one of the Netscapes, it's presumed to have been received when the addressee becomes aware of the information in the addressee's system and is capable of being retrieved and processed. So you don't actually have to read the communication. The fact that it's there, can be addressed, can be read, whether it is or not, doesn't matter. So as I say, the phrase "you have mail" may now become "you have a deal," whether you've read the email or not. There is some interesting provisions about where the contracts deemed to be made. Those are going to have, you'll have to sort those out in terms of conflict of laws and all the rest of those nice issues, but there is assistance from the statute. There is only, when you look at how this is going to work in the real world, there is one case that deals in Ontario, the only one that I've been able to find, that deals with contracts concluded entirely through electronic means pre-statute, and that's the Rudder case, which is referred to extensively in the materials. This was a case of the acceptance of a software license, and the software license included a term about where suits could be brought. Said you can only bring them, as I recall, in Washington. You can't sue even though Microsoft is here and you're here. You can't sue Microsoft. The contract says you can only sue in Washington. I wonder why that's there. The court in that case concluded that even though you had to scroll down through a whole bunch of pages to get to the venue clause, and even though you could click on it without having read any of that, the court held that this was no different than flipping through pages in a document, and the court held that that clause was enforceable and valid. The other bit of real law that's addressed in the paper, and you can read. I'm not going to take you through all of this law. Has to do with the best evidence rule, and there is reference to at least two cases. There are others in the paper where the courts have held that electronic documents can be accepted in evidence as the best evidence, and that even though a document may have ceased to exist, if there's a record of it, for instance, in the bank, and it's normally relied upon, that can still be the best evidence of a check having been sent or cleared or whatever. There aren't very many of us who, at least in the civil side of the practice, who have to worry about best evidence rules these days. I've never really come across it. People fire in photocopies as if they were real and authentic. But the statute does address this issue, and particularly this comes out of the amendments to the Ontario Evidence Act, which has a definition of electronic record that seems to be appropriately encompassing. and then says that a person seeking to introduce an electronic record has the burden of proving its authenticity by evidence capable of supporting a finding that the electronic record is what the person claims it to be. I'm not quite sure how you're going to go about all that. I guess you're going to have to do it the same way you do now for business records, and have somebody who's able to speak to the general business standards within the firm, and is going to be able to affirm somehow. You can do it by affidavit, as the statute provides. That's going to be able to affirm that the document meets those criteria. Subsection 5 of Section 34(1) of the new version of the Evidence Act does provide that the best evidence rule in respect of electronic record is satisfied on the proof of the integrity of the electronic record system. But there is one important point to note out of all this. If you're trying to introduce into evidence a document that your client created, you're going to have to prove the authenticity, the integrity of that document. If the electronic document comes from either the other party or a third party, there arises a presumption that the document is authentic and therefore will satisfy the best evidence rule. So it's going to create, I think, at least for starters, a small cottage industry in the examination for discovery process as you go through the other side's documents, trying to match them up precisely with all the documents in your own client's records. You don't want to have to go to court and prove the authenticity. You want to get them from the other side, and you want to avoid all of that problem. So that does make it both somewhat more cumbersome, but there is a way of dealing with that situation. There is one further amendment which is on the way. It's now in the form of Bill 119, which had first reading on October the 4th of this year, a further amendment to the Evidence Act that deals with the reliable encryption techniques, and if you are trying to authenticate documents, there is now provision that where you can prove that the reliable encryption technique of the kind of electronic signature that I spoke of earlier has been used, that will allow you as well to authenticate documents. So those are, I think, the main highlights of the new regime as it applies in Ontario. These same rules have been applied in Manitoba and I think in British Columbia. They're consistent with the federal scheme, and there is a whole federal scheme that has been laid on top of this. The federal scheme is known, it's a section of something wonderfully entitled Personal Information Protection and Electronic Documents Act, which is the federal statute, PIPEDA, it's called. And PIPEDA provides much the same as you find in Ontario, so that there is a congruence of the federal and the provincial rules. And there are amendments also enacted for the Federal Evidence Act, which are very similar. And in the paper, you'll find a bit of a concordance that takes you back and forth. So it's not exactly a brave new world, but there are some. It follows generally the pattern that you would expect it to follow. There are a few things you're going to have to watch out for, some areas that you'll want to advise your clients who are engaged in this business on, and all in all, a good start, but not terribly bold. We'll have to wait for the boldness to come later. Thank you.
Well, thank you, Mr. Scott. That's it may not seem bold to you, but to people still used to pen and paper, it is quite a dramatic change in the way things are done. Our next speaker is Jane Waechter, who is with the Smith Lyons firm. She practices in commercial litigation mainly. She is a former clerk at the Court of Appeal for Ontario, and she's one of these people who I find dreadfully intimidating in having a double designation. She received her Chartered Accountant designation in 1989. She'll be speaking today upon pretrial notices, Evidence Act notices, and everything you need to know about them. So if I could ask you to come forward. Thank you.
afternoon, everybody. As everyone in this room knows, there is a huge amount to remember when it comes to trial preparation. My paper that's presented in the materials is more of a reminder paper than a highly technical dissertation. It really deals with one aspect of trial preparation, which is notices that need to be provided to other people in connection with your preparation for trial. So in order to understand where I'm coming from in this paper and today in our discussion, it's quite helpful to divide trial preparation into two categories. The first would be your internal preparation, which deals with things like preparing your trial brief, interviewing witnesses, updating your legal research, and preparing your examinations and argument. So I would call that sort of internal preparation. Then there's external preparation, which is telling other people things that they need to know about your preparation for trial. And that's where pretrial notices come in. So in a sense, my paper is about that half of trial preparation, which is giving other people notices of important things. I have arranged my paper in by category of document, which is notices regarding witnesses or notices regarding documents or other things. Today I'm going to be speaking chronologically. From the time that an action is set down for trial, what is the first notice that you ought to be considering. Towards the end, I'll be dealing with some notices that don't really have a specific timeline prior to trial. That's a little more discretionary with counsel. And what I've done is I'm roughly following, if you're looking at the paper, the chart at the end of the paper, which gives a chronological ordering of the notices that I'll be discussing today. I too have a disclaimer. This paper doesn't deal with specialty areas of law. It doesn't deal with federal court rules. The notices that are discussed in the paper are from the Federal or Provincial Evidence Act and also from the Rules of Civil Procedure. If your action concerns a specialty statute, you ought to check that carefully as its own issue. So the action is set down for trial. The first notice that comes up or that could come up, is a notice if a party intends to abandon a claim of privilege over a document in Schedule B of the Affidavit of Documents. The applicable rule is Rule 30.09. This notice has to be given to all other parties 10 days after setting down the action for trial. So it comes quite quickly after setting down for trial, and it's one of those ones to keep your eye out for, because I think that most of us think that most of the pretrial notices come quite close to the trial date or the deadlines. What you need to do for this notice is provide notice to all of other parties that you intend to use a document over which you formally claimed privilege, and produce that document to them. Now, this rule actually only comes in limited circumstances, and it applies if you want to use a privileged document other than to impeach a witness. So you would still, if you're planning on bringing out something like surveillance evidence to impeach a witness, you don't need to worry about this rule. But if you are planning on leading evidence in chief based on a privileged document, you have to give your notice very early that you intend to waive that privilege and disclose the documents. This one, as many of the notices that I've reviewed, has a sort of what-if clause. If you forget to do this, you can apply for leave under Rule 30.09. And I guess, I mean, this can come up in different ways, but by the time you set up by the time that action is set down for trial, you should have a clear strategy as to how you intend to use that kind of privileged document. If it becomes apparent later that you need it for a purpose other than to impeach, you should produce the document as quickly as possible to alleviate the other side's arguments about prejudice. So you can apply for leave, and you should do it at the earliest opportunity if you haven't complied with this rule. But one way of lessening an argument that someone is very prejudiced by your late disclosure of the document is to disclose it as soon as it becomes apparent to you that you need it. The next chronological set of notices that come up are expert reports. The governing rule is Rule 53.03. These need to be served on all parties to the action on the 90, 60, 30-day rule that I think everyone is now well familiar with. The expert report, the initial expert report comes out 90 days prior to trial, responding in 60 days prior to trial, and the supplementary report, which would typically reply to the responding report, has to come out 30 days prior to trial. There's some technicalities in the notice provisions that you should be concerned with. The expert report must be signed. That's something that's easy to bypass. And it has to be accompanied with material setting out the name, address, and qualifications of the expert. So don't forget to get your CV served at the same time. The expert reports themselves are to contain the entire substance of the expert's proposed testimony, and that's something, again, that you're going to have to be very careful with to make sure something doesn't come up later that you'd really like your expert to talk about. You would be precluded by the rules from letting the expert discuss any matter that's not in the initial report or a reply report, except with leave of the court. So again, there's a what-if clause. If you don't get everything in, you could apply for leave to serve late on an issue you may have forgotten. The why for this report, why do you do this? You do it so that you can lead expert evidence. That's pretty clear. There's another set of provisions that we occasionally need to remind ourselves of if there's a large number of experts testifying. If you plan to call more than 5 experts, you require leave of the court under the Canada Evidence Act to do so. Under the Ontario Evidence Act, you need that leave if you're going to be calling more than 3 experts. So you should consider that early and think about your leave argument. In this regard, I'd actually refer you to a recent decision, or a last year's decision by Mr. Justice Farley called TD Bank and E. Goldberger Holdings, where he said, make sure that your experts are really experts. That people are advancing too many people as alleged experts when really they aren't appropriate experts from the court's perspective, and he refused to grant leave to lead evidence from that type of, in his view, non-expert expert on an application under these Evidence Act rules. If you find that you're unable to get your expert report served on time, there are leave provisions as well. You can ask for an extension at the pre-trial conference, at a case conference under Rule 77, or on a motion to the court. So there is a way to relieve against compliance with these rules if you have, for some reason, an inability to meet the timing requirements. And on that, the general rule would be that you should do so as soon as possible. Try to get that extension. The next in chronological order is request to admit. Those actually, requests to admit are going to be discussed in more detail by someone else tomorrow, so I've only included it in my paper as a reminder on your timeline that the last time that you could serve it is 20 days, or really 21 days prior to trial, in order for it to be effective for use. And again, it needs to be served on whatever parties you're requiring to make the admissions set out in the request to admit. Coming a little closer to the trial date, there's notice of constitutional questions under Section 109 of the Courts of Justice Act. This notice should be served as soon as you become aware that there's a constitutional issue that's going to come up at your trial. The notice needs to be served on all of the parties to the action, the Attorney General of Canada and the Attorney General of Ontario. This notice needs to be served a minimum of 15 days before the hearing where the constitutional question will be argued. And there's a prescribed form that it needs to be in, which is Form 4F in the Ontario rules. You use this notice if you want to challenge the constitutionality, which is either the validity or applicability of a constitutional provision with respect to a federal or provincial statute, a regulation or a bylaw under those statutes, a rule of common law, or where there's a remedy under Section 24(1) of the Charter that's going to be examined at your trial. The what if of this, what if you forget to do this, is a little more difficult for constitutional questions because Section 109, subsection 2 of the Courts of Justice Act says that you cannot have any adjudication on constitutionality if you don't serve this notice in accordance with the requirements of the Courts of Justice Act. So that's one where I'm sure that there are imaginative people who can sort of think up a good motion for leave, but the statutory provisions are mandatory on that notice. And there is no specific relieving provision, so best to get that one out on time. Getting still closer to trial, under the Ontario Evidence Act, Section 52, it's possible to lead medical evidence by a written report. You need to give 10 days notice to the other parties of your intent to use this provision, and you must obtain leave of the court, so it's not actually a freebie where if you give notice you're automatically entitled to something. What you need to do if you want to take advantage of this provision is serve the notice, serve the medical report, and serve any other notice or any other report that has been prepared by the same practitioner. You would do this, and I don't think that it's all that often used, but you would do it if you don't intend to call the witness to give live evidence at trial, and that would most likely be where there's not going to be a real issue of credibility, and it's not highly contentious. So this is a notice that's available if you have those kinds of circumstances, but in any event, you need to get leave of the court. So it's something that you need to notify the other side within 10 days before the trial, but then you'll also need the court's permission to lead evidence that way. Another notice that may come up is under Section 53 of the Ontario Evidence Act. That one is applies if you intend to prove title documents at a trial. You need to serve this notice to all parties in the action 10 days before the trial. And what you do is you serve a notice of your intent to give in evidence, a certified copy of the title document. So you get the title document certified by the land registrar, and then you serve notice that you intend to prove the document that way. And what this means to you is that you don't have to prove an original, that the certified copy is sufficient evidence of the document, its validity, and its contents. Now, if you're on the receiving end of that kind of notice, you have 4 days to serve a notice that you're going to require the other side to prove the original. And if you take that position as on the receiving end of that document, the issue of whether it was reasonable for you to require the long form of proof is something that the court will address in costs. So it probably should be quite contentious before you oppose that kind of notice. Another Evidence Act notice that comes up shortly before a trial is in Section 55 of the Evidence Act. It applies to a whole set of documents that are set out in the Ontario Evidence Act. It applies to telegrams, letters, shipping bills, bills of lading, delivery orders, receipts, accounts, or other written instruments used in business or other transactions. So it's quite comprehensive in its applicability. This notice needs to be served on all parties within 10 days prior to trial. In order to meet the technical requirements, you need to serve the notice that you intend to prove documents through Section 55 and name a convenient time and place for inspection of the documents. Again, if you take advantage of this provision, then a copy of the record that you intend to rely on at trial is sufficient proof of the record's contents. If you're on the receiving end of this kind of notice, again, 4 days. You can complain within 4 days and require a proof of the original. And again, if you're wrong about it as the receiving party, that is a matter that will be addressed by the court in costs, whether it was reasonable for you to require proof of the original. The one that we all know about and never seem to need to be reminded about are the business records notices. There's provisions in Section 30 of the Canada Evidence Act and in Section 35 of the Ontario Evidence Act about business record notices. Those both need to be served 7 days prior to the commencement of trial. In order to take advantage of these provisions, you need to serve the notice and you need to produce the documents for inspections within 5 days after getting notice from the other side that they want to inspect the documents. There's a really big why do you want to do this with respect to business records. The fundamental reason why is you don't want to have to prove an original. This has obviously come up because very often we can't even identify the author of some business records. So you don't have to find that person and bring them to court to prove the document. That isn't always necessary under the common law. There's the rule in Aries and Venner sets out the common law requirements for avoiding or the common law hearsay exception that lets you prove business records, but it's got more requirements than the Evidence Act requirements. So you have more hurdles to jump through if you want to rely on Aries and Venner to prove your business records. So in essence, we all serve these notices because it's going to save us a lot of aggravation in terms of proving the business records. The Canada Evidence Act actually has fewer requirements for records that can be proven under its provisions. What it requires is that the document or the record is made in the usual and ordinary course of business, and that oral evidence of the subject matter of the record would be admissible at the trial. The Ontario Evidence Act is a little dicier. It has a couple extra requirements. One is that the record needs to be normally made by the business. So it has to be a usual business record as opposed to just a business record. There's a requirement under the Ontario Act that the record was produced contemporaneously with the matter recorded or awfully close to contemporaneously. And the record can only be admitted under the Ontario provision as evidence of an act, transaction, occurrence, or event. So the Ontario statute is somewhat narrower than the Canada Evidence Act. There are a couple of additional requirements that you have to be aware of in the Canada Evidence Act, and that's requirements for affidavits in respect of the business records. Where you're going to be producing a copy of a business record under the Canada Evidence Act, there are two affidavits that are required under Section 30 of that Act. One is an affidavit saying why it's not possible or reasonably practical to produce the original. And the second is an affidavit by the person who made the copy saying that saying what the source document was and that the copy is an authentic copy. And those affidavits are technically required to be mentioned in your Evidence Act notice, your business records notice, if you're going to be dealing with copies. A second affidavit that comes up in the Canada Evidence Act in respect of business records is it comes up when the business record needs an explanation. And what's required then is that you get a qualified person from the organization that produced the record, and you have them swear an affidavit explaining their qualifications to explain the record, attaching an explanation of the record, and swearing to the accuracy of the explanation of the record. So if you're dealing with highly technical documents that really aren't obvious, that is not obvious from their face what they tell you, then you have to consider the need for that kind of affidavit, and it needs to be mentioned in your business records notice. There, again, for the Canada Evidence Act and the Ontario Evidence Act, if you don't serve the notice on time, you can apply for leave. And there's a recent case that is referred to in my paper called Nouveau Electronics and London Assurance. And in that case, the court said, we'll give leave unless prejudice can be shown. So it's not a super high threshold, but it's probably a little easier on counsel. It's definitely easier if you just serve it on time and you don't have to meet a possible prejudice argument that could keep you from using the notice or the records at trial. Another document that needs to be sent out prior to trial is an offer to settle under Rule 49. I've included it in my paper, not by way of sort of having a detailed discussion about Rule 49 offers, but just as a reminder to keep your eye on the last date that you can serve an offer to settle before the trial, so you don't get caught off guard without an effective Rule 49 offer. Most people like to serve them a lot earlier than that, and that's a pretty good plan because of the consequences, but you should always keep a reminder out there for your 7 days before the trial commences. Another kind of record that you need to jump through hurdles with and give notice of your intent to prove them are banking records. There's special provisions in Section 29 of the Canada Evidence Act and Section 33 of the Ontario Evidence Act. If a person wants to rely on banking records at trial, in a general sense, these don't seem to apply to actions where a bank is a party, but certainly where records are sought from a bank and intended to be used at trial, there's a very specific procedure that has to be followed. And it seems that a lot of people believe the way to get banking records available and usable at trial is just to serve a summons on the bank, and that is pretty much completely wrong. What you need to do is you need to comply with the requirements of the Section 29 of the Canada Evidence Act and Section 33 of the Ontario Evidence Act. And what it basically requires is you have to give notice to the financial institution and its customer that you want to inspect the bank's records. And you bring a motion to get leave to inspect the records. And what that'll get you is this. You'll get to look at the bank records, you'll get to take copies of the bank records, and then you get to prepare an affidavit from a banker stating various things about the records and then the affidavit will be your evidence at trial about the bank records. So the affidavit that you'll need to prepare is to be sworn by an appropriate person at the bank, and it needs to actually contain this information. First, that the record that is being produced was an ordinary record of the bank. Second, that the entry in the record was made in the usual and ordinary course of business of the bank. Third, the record is in the custody or control of the bank. And fourth, that what is appended to the affidavit is a true copy of the record. So this is one of those things that you need to actually get on fairly soon before trial. Like, don't let this one linger, because first you have to get access to the records, and then you have to prepare this document to get the banking records in an appropriate way. The Evidence Acts say that a banker is not required to give evidence at a trial about banking records unless special cause is shown. So it's best to get these out if you need those documents and follow these requirements to the letter. As well, I think that a lot of us have experience with trying to retrieve documents that are microfiched and old in a bank, so that you might want to do this quite early, even though the notice requirements are technically quite short. And the reason for this, for all of these hurdles, is quite simply that the bank can't disclose its customers' records to other people because of its duty of confidentiality. So that by giving notice to the bank's customer and giving them an opportunity to complain about the use of their records, then the bank is then cleared by the court to disclose the documents. There's another set of notices that need to be given to people, sometimes parties and sometimes other than parties, leading up to trial. And they actually don't have specific time limits, as in 7 days before trial or 10 days before trial. But there are a number of other notices that I've put forward for your consideration. One thing to consider is getting production of documents from non-parties under Rule 30.10. What you need to do is bring a motion on the usual notice, giving notice to the parties to the action and the non-party. What you need to do is get a specific order for production from the non-party, and the test is essentially that the documents that you're seeking have to be relevant to a material issue in the action, and you have to demonstrate as a moving party that it would be unfair for you to proceed to trial without production of these documents. Now, there's a fair deal of case law under this, what would make it unfair and so on. But basically, you would probably want to bring this kind of a motion after examinations for discovery have left you in a position where you don't have records that you really need for trial. The court will look at a number of factors to see whether they'll give you this relief. One is how important is the document, how invasive is it to the non-party, whether a party to the lawsuit is partly responsible for your inability to get the document that you're looking for. Really just simply what the non-party has to say on the issue. If they don't want to produce it and have a really good reason, then I guess they'd be seriously considered. And these are not orders that are granted lightly because it's invasive to the non-party. So you really have to sort of carefully prepare your materials. And you'd want to bring this kind of a motion sufficiently in advance of the trial that you'd have a reasonable opportunity for the non-party to put together the records, and then for you to review them and figure out what you're going to do with them at the trial. I guess if you don't get that order, then your fallback position is to serve a summons on the non-party, but to come to trial. That's just one of those last-minute preparation things, so it's better to try to move if you think that you can meet the requirements of the rule. Other notices that you need to send out, don't forget your summons to witnesses. That's a notice to someone who's not a party but is going to be a witness. Basically, your timing on that is you need to serve it sufficiently in advance of the trial that you're sure you can get it served. You need to effect personal service. Your notice has to set out the time and location of the trial, and if you have relevant records that you want the person to bring with them, you should specify them with particularity in the summons, because the general blurb isn't usually helpful to most potential witnesses. There are special rules that you should take a look at if you've got an extra provincial summons. If the person is out of Canada, you'd have to look at taking evidence by letters rogatory. There's special rules for witnesses in custody that you should remember, and there is also a special rule if you want to call an adverse party as a witness at trial. You need to give 10 days notice, and you're entitled to call the adverse party unless that person has already testified, or unless the adverse party actually undertakes to call the person as a witness at the trial. So just be careful of those kind of things, because if you don't get your witnesses, if you can't compel your witnesses to attend, then you're exposed at the trial, and you'd be left at the outset of a trial asking for an adjournment because you haven't been able to compel your witnesses to come. Another notice that you could consider using coming up to a trial is a motion to permit the use of affidavit evidence at trial. And you might consider that if you have some minor points that need to be proven, but they're not very contentious and you're not really going to have a credibility issue with your witness. What you can do is apply, bring a motion for an order to permit you to use the affidavit to either prove a fact or a document. And it's really only appropriate where the evidence isn't contentious or there's not a credibility issue, but it can save you time at the trial if it's really a minor point. So that's another one that you could consider, and that must be done on notice to all parties. Another notice that you should consider leading up to trial is whether you need to conduct pretrial examinations under Rule 36.01. This rule needs to be considered if you've got a problem with a witness. Either the witness is out of the jurisdiction when you might want to take evidence under letters rogatory, or the witness is ill or frail. You might want to make sure that you get that evidence before the trial. That evidence can be, you can either bring a motion to get your evidence that way, or obtain the consent of the other parties and the person if they're different than a party. The court would actually look at a number of factors that are set out in Rule 36, the convenience of the person to be examined, the possibility that the person won't be available at trial to testify, the possibility that the witness will be beyond the jurisdiction of the court, the expense of bringing the person to trial, and whether the person ought to give evidence at trial, sort of in the, is this evidence necessary? So you could consider whether you need to give that type of notice leading up to your trial. And the final notice that I've put forward for consideration is this notice that everybody knows about, which is your continuing disclosure obligation under Rule 30.08 and 31.09. If you become aware of an additional fact, if you become aware of an additional document, you must give immediate notice to all other parties that this new fact has come forward or that you've got a new document. The rules are quite explicit about that. The timing requirement is immediate. If you don't give that kind of notice, then you'll likely be prevented from leading evidence on that fact or adducing the document at trial. And certainly you could apply for leave, but it's not one that's considered very fair by the courts, so you'd want to be able to demonstrate that it had really only come to your attention the moment before you disclosed it to everyone else. So I've actually sort of run through a marathon of a whole bunch of notices that you should consider bringing leading up to a trial. It's not completely comprehensive, but it's put forward really as a checklist or a reminder. Some of these things we once knew and forget over time. Some of these things, I mean, I was a bit surprised to be reminded of the affidavits that are required under the Canada Evidence Act. I thought that I had that one straight and then saw the requirement and said, oh boy, there's another technicality that I have to continue to keep a watch for. The real lesson, in most cases for most of these notices, you can get leave if you don't serve the notice on time. But if you can serve it on time, why wouldn't you just save yourself the cost and the trouble and occasionally the anxiety of whether you're going to get leave or not? Really, each of these notices its sole purpose is to make life easier for you at trial so that you don't have to do things the hardest and longest way. And I would say that a subsidiary issue that you always have to keep in mind is, even though there's time limits that are set out, it's better to serve these notices early so that you don't run afoul of any of the timing rules. And there's not really, in most cases, there's not really any advantage to waiting until the last minute for service. So the messages are essentially, there's this great huge bunch of notices that you've got to keep in mind. And it's your whole set of warnings to the other side of what you're going to be doing, or to witnesses who aren't parties of what you plan to do at the trial. And there are timing requirements that you should try to comply with. And if you do, your life will be much easier.